All right. So, I'm going to attempt to do 3 articles at once, like I attempted to do last time, but one article just took too long and I decided to scrap the multi-article video. Well, let's hope this time I can get through 3 articles because they're all good news. So, and 2 of them are Supreme Court rulings, so considering the Supreme Court, the fact that I'm saying good news on 2 of them, surprising that we're not getting a lot of bad decisions. So, makes me wonder what doozy is coming along that they're teasing us with all this good stuff. But anyway, first article. The Supreme Court rules for Biden administration in a social media dispute with conservative states. The Supreme Court on Wednesday sided with the Biden administration in a dispute with Republican-led states over how far the federal government can go to combat controversial social media posts on topics including COVID-19 and election security. By a 6-3 vote, which oddly enough is not, I expect that vote, but not on the side of good. So, yeah, I'm curious who were the dissenters. The justices throughout lower court rulings had favored Louisiana, Missouri, and other parties in their claims that officials in the Democratic administration leaned on the social media platforms to unconstitutionally squelch conservative points of view. I'm sorry, if your point of view is misinformation, is that really a point of view? But anyway. Justice Amy Coney Barrett wrote for the court that the states and other parties did not have the legal right or standing to sue. So it's again on a technicality rather than they actually believe that this is right. Okay. Justices Samuel Alito, Neil Gorsuch, and Clarence Thomas dissented. The decision should not affect typical social media users or their posts. Right, because as long as you're not, spreading disinformation, you're good. The case is among several before the court this term that affect social media companies in the context of free speech. In February, the court heard arguments over Republican-passed laws in Florida and Texas that prohibit large social media companies from taking down posts because of the views they express. In March, the court laid out standards for when public officials can block their social media followers. The cases over state laws and the one that was decided Wednesday are variations on the same theme. Complaints that the platforms are censoring conservative viewpoints. The states have argued that White House communication staffers, the Surgeon General, the FBI, and the U.S. Cybersecurity Agency are among those who applied unrelenting pressure to coerce changes in online content on social media platforms. Yes, I recall that there was a hearing, and thanks to that hearing about Twitter, it is now in the congressional record about Chrissy Teigen calling Donald Trump a pussy-ass bitch. So that's how far things had gone. The justices appeared broadly skeptical of those claims during arguments in March, and several worried that common interactions between government officials and the platforms could be affected by a ruling for the states. The Biden administration underscored those concerns when it noted that the government would lose its ability to communicate with the social media companies about anti-Semitic and anti-Muslim posts, as well as on issues of national security, public health, and election integrity. Now, I do see where the conservative states are coming from. if indeed this is what they're arguing, is that some bad actors, say Trump, will consider things like, say, Biden won the election in 2020 to be disinformation and could try to compel the platforms to take down posts it what's the word? Accepting the fact that he did in fact win the election. So I could see from that standpoint, but yeah, it turns out they don't have standing, so that's how they're sidestepping this issue. White House Press Secretary Karine Jean-Pierre said the court reached the right outcome because it helps ensure the Biden administration can continue our important work with technology companies to protect the safety and security of the American people. After years of extreme and unfounded Republican attacks on public officials who engaged in critical work to keep Americans safe. And that's the other thing. They're whining that posts with misinformation that they're pushing are being taken down when they had no problem attacking anybody and everybody who disagreed with them. So, wait. Why are you whining when you're the ones who are doing the attacking? Louisiana Attorney General Liz Murrill called the decision unfortunate and disappointing. The court majority, Murrill said in a statement, gives a free pass to the federal government to threaten tech platforms into censorship and suppression of speech that is indisputably protected by the First Amendment. The majority waves off the worst government coercion scheme in history. Now, first off, they didn't say that at all. It sounds like they agreed with the Biden administration on a technicality that these people don't have standing. That's one. But I would like to see what the safeguards are, because I could see, the Biden administration, I look at as an administration that actually cares about free speech and truly only goes after the truly horrible posts that spread disinformation. But, yeah, in the hands of someone, say, like Trump, it could be turned on its head, which is why conservatives have to be very careful. But again, this was on a technicality that these people don't have standing to sue. So why are you complaining? Find a case where they're standing and try again. Maybe you'll get the outcome you want. Maybe you won't. Because I don't know the specifics to this case, but there's a difference between we're going to take you down because you're conservatives, and we're going to take you down because you are pushing all sorts of horrible ideas. Now, if you considered that to be one and the same thing, being conservative and being full of hate and lashing out at anything and everything you hate and spreading disinformation just so you can hate, if you consider those two to be synonymous, then you are the one with the problem, not conservatism as a whole. So, let's continue. The justices did not weigh in on any substance of the state's claims or the administration's response in their decision Wednesday. Exactly, because they found that they don't have standing. So why go into an exercise where it doesn't really matter? We begin and end with standing, Barrett wrote. At this stage, neither the individual nor the state's plaintiffs have established standing to seek an injunction against any defendant. We therefore lack jurisdiction to reach the merits of the dispute. In dissent, Alito wrote that the states amply demonstrated their right to sue. For months, high-ranking government officials placed unrelenting pressure on Facebook to suppress Americans' free speech. Because the court unjustifiably refuses to address this serious threat to the First Amendment, I respectfully dissent, he wrote for the 3 justices in the minority. Yeah, you're just whining because you were found out to be an insurrectionist. Good God. All right. Some free speech advocates praised the result, but lamented how little guidance the court provided. Exactly, because again, this is about standing, not about the actual merits of the case. It was about standing. So of course they didn't delve into the particulars, because what's the point if these people don't have standing? They're going to wait for people who have standing. And so the conservative states are just going to have to find someone with actual standing. All right. The platforms are attractive targets for official pressure, and so it's crucial that the Supreme Court clarify the line between permissible attempts to persuade and impermissible attempts to coerce, said Alex Abdo, litigation director for the Knight First Amendment Institute. This guidance would have been especially valuable in the months leading up to the election. Again, they've discovered that there wasn't standing, so there was no reason to delve into that. Nina Jankowicz was named in the original lawsuit after being appointed in 2022 to lead a new board within the Department of Homeland Security to tackle disinformation. The board was dissolved within weeks amid conspiracy theories and criticism from Republicans and conservative activists who saw the effort as a political tool to regulate free speech. It is just amazing to me how they're whining constantly about free speech, but if someone were to say something against them, and I've had this in my groups, that if someone says something that you don't like and you point out where they're wrong, then somehow you're stepping on their free speech. So the very people who are pounding their chests about free speech actually only care about their own speech and nobody else's. Jankowicz, an expert in disinformation, said the Supreme Court had done what she had expected, but she said the damage from the lawsuit is not easily fixed. Unfortunately, there's an entire class of people that now believes the government, in coordination with independent researchers, is censoring some parts of the American population, she said. I don't think that's going to go away anytime soon. Exactly. The right is so good at spreading propaganda that for some reason people are willing to believe, but they're not willing to believe what their own freaking eyes tell them. It's just bizarre. I just do not understand how the right got their claws into this so well. The court's ruling comes as many social media companies have removed guardrails against hate and disinformation. See Twitter. The social media platform X, under the leadership of owner Elon Musk, has restored the accounts of conspiracy theorists and extremists who were previously banned. It has also gutted teams that once fought misinformation on the platform, leaving the community of users to moderate itself. Because again, Elon Musk claims to be a free speech absolutist, except when people go after him or attack viewpoints he agrees with. Then suddenly he's not a free speech absolutist. Experts say the shrinking of such teams, a development that many blame on political pressure, could make election-related disinformation across social media worse in 2024 than was in 2020. Meanwhile, Meta, which owns Facebook and Instagram, has pivoted away from emphasizing news and political content on its platforms after facing years of accusation that mishandles misinformation and contributes to political polarization. A panel of 3 judges on the New Orleans-based Fifth U.S. Circuit Court of Appeals had ruled earlier that the administration had probably brought unconstitutional pressure on the media platforms. The appellate panel said officials cannot attempt to coerce or significantly encourage changes in online content. Yeah, but I'm sure those justices would have no problem explaining away how Trump actually threatened the NFL when Colin Kaepernick and other people were kneeling for the anthem. But, that was probably just fine and dandy, but when people are trying to keep disinformation at bay, oh no, that's bad. The decision was the 6th this term in which the court threw out rulings by the Fifth Circuit, which is just shocking to me. One of the nation's most conservative appeals courts, which is why it's shocking to me. Last week, the court upheld a gun restriction aimed at protecting domestic violence victims, overturning a Fifth Circuit panel. Earlier in June, the court unanimously ruled that anti-abortion doctors lacked standing to challenge Food and Drug Administration decisions to ease access to the abortion drug mifepristone. The case is Murthy v. Missouri, 23-411. The AP ends their articles so weirdly. It's like one person wrote it and said, okay, I'm going to just submit this and then let somebody else revise it later when it's already been published. It's just bizarre. So that is all I have on that opinion. Now, there was something I was going to mention about that. Let me just bring that up again. Too far. What was I going to bring up? Oh, come on. Oh, yes. And this is going to be shown in the next article I'm going to read. But it seems like it's not so much that they're ideologically, that the court has changed their ideology or that they are becoming more liberal or whatever. I think they're just reality is making them realize the consequences to their views. A former ruling that they realized is allowing domestic abusers to access guns, and they're like, wait a minute, we didn't actually mean for people to actually get killed, because, unfettered access to guns wasn't meant to do that or something. Anyway, to the next opinion, which I can't call it an opinion because this was more of a oopsie. Just like Dobbs a couple of years ago, this opinion was accidentally posted before the justices were ready. So either this is their actual opinion, or it's going to turn, or maybe it was just a rough draft and they're still working it out. But I'm thinking it's like Dobbs and it was just somebody posted this prematurely. Now, whether they did it for specific reasons or if it was truly an accident, just like Dobbs, don't know, but this one is an actually good decision. Justices seem to set to allow emergency abortions in Idaho for now, a prematurely posted opinion says. Now, Amy Coney Barrett did actually sound absolutely flabbergasted when she realized what her stance on abortion actually does in reality. It's like it never occurred to her what saving the life of the mother actually meant. So she was just outraged when she heard the state of treatment for pregnant women in Idaho who needed emergency care. But anyway, let's get to the article. The Supreme Court appears poised to allow emergency abortions in Idaho when a pregnant patient's health is at serious risk, according to a copy of the opinion briefly posted on the court's website Wednesday and obtained by Bloomberg News. The document suggests the court will find that it should not have gotten involved in the case over Idaho's strict abortion ban so quickly. By a 6-3 vote, it would reinstate a lower court order that had allowed hospitals in the state to perform emergency abortions to protect a pregnant patient's health. And I'm really curious who the 3 dissenters are, but since this was prematurely leaked, I don't know if we'll learn that. Such an outcome would leave the issue at the heart of the case unresolved. It would also mean key questions remain unanswered, Justice Ketanji Brown Jackson wrote in a concurrence. Whoa, so a lot got leaked. Today's decision is not a victory for pregnant patients in Idaho. It is a delay, she wrote. The Supreme Court acknowledged that its publication unit inadvertently posted a document Wednesday. An opinion in the Idaho case would be issued in due course, Court spokeswoman Patricia McCabe said in a statement. You're running out of time, guys. So, usually their term is till the end of June. It's the end of June. You don't have a lot of time now. Conservative justices Clarence Thomas, Samuel Alito, and Neil Gorsuch are listed as dissenting from the decision. Oh, no surprise there. The finding may not be the court's final ruling because the justice's decision has not been officially released. This decision would mean the case would continue at the 9th U.S. Circuit Court and could end up back before the justices. The Supreme Court may be reluctant to make an abortion-related decision on the merits, rather than procedural grounds, in an election year, said Greer Donnelly, a reproductive law scholar and professor at the University of Pittsburgh School of Law. A new poll from the Associated Press Nork Center for Public Affairs Research found that about 7 in 10 U.S. adults favor protecting access to abortions for patients who are experiencing miscarriages or other pregnancy-related emergencies. And I keep saying that how about we don't ask people their opinion about it. We don't ask lawyers their opinion. We just let the woman and doctors decide whether an abortion is needed, because they're the ones who are involved. They're the ones who are aware of what could go wrong, because they might be experiencing that very thing going wrong. So, the decision would reverse the Supreme Court's earlier order that allowed an Idaho abortion ban to temporarily go into effect, even in medical emergencies. Several women have since needed medical airlifts out of the state in cases in which abortion is routine treatment to avoid infection, hemorrhage, and other dire health risks, Idaho doctors have said. And this is part of Amy Coney Barrett's shock that medical emergencies actually exist, and that this is making things dire for women. Because she, like so many people on the anti-choice side, seem to be of the opinion that they know why women get abortions, they know what it entails, and they know that women just recover the next day or something. So, yeah, this is basically people like her being confronted with the consequences of their not knowing what the fuck they're talking about. The nation's top health official, Xavier Becerra, I don't know, held a scheduled meeting with Idaho doctors and patients to discuss the state's strict abortion ban in Boise Wednesday. Sarah Thompson, an Idaho OBGYN, said that if a woman's water breaks early in pregnancy when the fetus has no chance of survival, she is unable to treat the patient by delivering the baby early. Exactly. Because viability means nothing to these people. While there's nothing we can do to save her baby, there is something we can do to preserve her health and her future fertility, Thompson said. You know, it's just so ironic that this women should be popping out kids like Pez dispensers are so willing to leave women infertile because they're not getting the necessary medical care they need, because people think abortions are icky, which they are. But if you have to have one, you have to have one. I mean, come on. There are lots of things that are icky. Doesn't mean that they shouldn't be done. The American College of Obstetricians and Gynecologists said that it hoped the court listened to the scientific evidence and medical experts and will ultimately affirm the availability of emergency abortion care for people in every state, said General Counsel Molly Megan. The case started when the Biden administration sued Idaho, arguing that its abortion ban conflicted with federal health care law because doctors wouldn't be allowed to provide abortions to stabilize pregnant patients in rare emergency cases when their health is at serious risk. And I cannot believe that's just Idaho that has this. I find that hard to believe. I mean, you saw in Texas, women suing Texas because they wouldn't let them have an abortion even when it was medically necessary. So, Idaho argued its ban does allow abortions to save a pregnant patient's life and that federal law does not require the exceptions to expand. The state attorney's general office declined to comment Wednesday. You know, that's a funny statement. Save a pregnant patient's life. At what point on their deathbed do they have to be before it's saving their life? And okay, you saved her life. Now this woman who wanted to have kids, who wanted to possibly push out kids like a Pez dispenser, now can't be able to do that because she couldn't have an abortion until the very last freaking moment. So, how is that better exactly? Katie Daniel, the state policy director of Susan B. Anthony Pro Life America, said an Idaho state court had ruled that women's lives don't need to be in immediate danger to act. Most Republican controlled states began enforcing restrictions after the justices overturned Roe v. Wade 2 years ago, and Idaho is among 14 states that allow abortion at all stages of pregnancy with very limited exceptions. Okay, the fact that doctors are absolutely afraid to perform abortions tells you that your claim that abortions are allowed when women's lives, that the court ruled women's lives don't need to be in immediate danger to act. Well, the fact that doctors are unsure of what the law says, and so they lean towards not performing an abortion and airlifting the woman outside of Idaho, kind of tells you that the law sucks. Even if you didn't mean it to go that far, it did go that far. So maybe just scrap the law? Most Republican-controlled states began enforcing... Whoops, I read that already. The case is likely to return to the Supreme Court again, said Rachel Rabouche, dean of the Temple University Beasley School of Law and a reproductive law scholar. The New Orleans-based 5th U.S. Circuit Court of Appeals has ruled in a similar case that the federal law does not take precedence over an abortion ban in Texas. Even though we do have that is a thing. Federal law supersedes state law. But the Fifth Circuit doesn't like what the federal law says, so they're going to go with the state law. That's not how law works. That's not how the Constitution works. What the hell? So while the Supreme Court's ruling would allow abortion in medical emergencies in Idaho, at least for now, Rabouche said, nearly 38 million people live in the Fifth Circuit. That's a lot of people whose lives aren't changed at all by this. Alexis McGill Johnson, President and CEO of Planned Parenthood Federation of America, said that's a decision without explicit guarantees that patients could get abortions in medical emergencies would be catastrophic. Reports of pregnant women being turned away from U.S. emergency rooms spiked after the Supreme Court's 2022 ruling overturning the constitutional right to abortion, according to federal documents obtained by the Associated Press. If the High Court were to rule in Idaho's favor, it would create a world in which women would have to lose their reproductive organs, said Sarah Rosenbaum, a George Washington University health law and policy professor who is an expert on the federal EMTALA law. And I'm sure a lot of people would be perfectly fine with that because the cruelty is the point. Because if you can look at all these horror stories and think, oh, well, then you're the monster. I mean, it's just that simple. You're a monster. The Justice Department's lawsuit came under a federal law that requires hospitals accepting Medicare to provide stabilizing care regardless of a patient's ability to pay. The law is the Emergency Medical Treatment and Labor Act, or EMTALA. Nearly all hospitals accept Medicare, so emergency room doctors in Idaho and other states with bans would have to provide abortions if needed to stabilize a pregnant patient and avoid serious health risks, such as the loss of reproductive organs, the Justice Department argued. Idaho argued that its exception for a patient's life covers dire health circumstances and that the Biden administration misread the law to circumvent the state ban and expand abortion access. Um, yeah, there's more to emergency care than just the patient's life. All right. Carol Tobias, president of the National Right to Life Committee, oh, this is going to be a doozy, said his group, okay, never heard of a him who named Carol, but okay, said his group was glad the Justice Department said its arguments applied to rare cases. Because it does. Just because you have a fever dream that pro-choice advocates want abortions to be happening 24/7, 365, doesn't mean that's actually happening. Doctors have said Idaho's law has made them fearful to perform abortions, even when a pregnancy is putting a patient's health severely at risk. The law requires anyone who is convicted of performing an abortion to be in prison for at least 2 years. Now, doctors are smart people. If they can't even make heads or tails of what they can and cannot do, again, maybe change the law. Or better yet, let the doctors practice medicine and stay out of their business. Because you obviously don't have a medical degree, so you have no idea what you're talking about. A federal judge initially sided with the Democratic administration and ruled that abortions were legal in medical emergencies. After the state appealed, the Supreme Court allowed the law to go fully into effect in January. Okay, and that is the end of that article. And I swear that last paragraph should have been at the beginning. And the AP is just weird with the way they do their articles. Anyway, so sort of good news. That's the sort of good news like I expected. Because, again, it's not the actual opinion. So let's go to the last article. And this is definitely good news. Biden pardons potentially thousands of ex-service members convicted under now repealed gay sex ban. And the gay sex ban in question is the, just keep thinking don't say gay, but that's the Florida one. Don't ask, don't tell. Ugh. President Joe Biden pardoned potentially thousands of former U.S. service members convicted of violating a now repealed military ban on consensual gay sex, saying Wednesday that he is righting a historic wrong to clear the way for them to regain lost benefits. Biden's action grants a pardon to service members who were convicted under the Uniform Code of Military Justice's former Article 125, which criminalized sodomy. The law, which has been on the books since 1951, was rewritten in 2013 to prohibit only forcible acts. I don't know what's more disturbing. That people were dishonorably discharged for this, or the fact that the law was only rewritten in 2013. Those covered by the pardon will be able to apply to receive proof that their conviction had been erased, petition to have their discharges from the military upgraded, and move to reconsider lost pay and benefits. Today I'm righting an historic wrong by using my clemency authority to pardon many former service members who were convicted simply for being themselves, Biden said in a statement. We have a sacred obligation to all our service members, including our brave LGBTQI+ service members, to propel, prepare, and equip them when they are sent into harm's way, and to care for them and their families when they return home. Today we are making progress in that pursuit. I just find it really odd that the military was so quick to stop gay sex from happening, because that's obviously bad. But women who suffer rape or sexual discrimination or harassment, yeah, we're not going to do anything until the news media reports on it and shames us into pretending to do something about it. Huh? The president's use of his pardon powers is occurring during Pride Month, and his action comes just days before he is set to hold a high-profile fundraiser with LGBTQ donors in New York on Friday. Biden is trying to rally support within the Democratic-leaning community ahead of the presidential election. Modern Military, the nation's largest organization of LGBTQ+ service members and their families, said the decision was a historic step towards justice and equality, and called on the military to approve the pardons quickly. Does the government do anything quickly? Biden's proclamation is a significant move in recognizing and righting the wrongs inflicted upon LGBTQ+ service members who face discrimination and unjust convictions under policies such as Don't Ask, Don't Tell, the organization said in a statement after the pardon announcement. These brave individuals stood on the front lines of freedom, risking their lives to defend our country, only to be met with injustice at home. Senate Majority Leader Chuck Schumer, Democrat from New York, said in a statement that the actions were a step in the march toward greater equality and correct a historic wrong for LGBTQ+ Americans who served bravely in our armed forces to keep our country safe. Administration officials declined to say why Biden did not act on the pardon sooner. This is the third categorical pardon by Biden, using his clemency powers to cover a broad group of people convicted of particular crimes, after moves in 2022 and 2023 to pardon those convicted federally for possessing marijuana. The White House estimates that several thousand service members will be covered. The majority convicted before the military instituted the Don't Ask, Don't Tell policy in 1993 that eased the way for LGBTQ+ troops to serve if they didn't disclose their sexual orientation. That policy was repealed in 2011, when Congress allowed for their open service in the military. And the fact that this was done in the 90s is just sickening. Granted, Bill Clinton thought that this was a compromise, but I get his point that at least they can serve, but then again, no. Service members convicted of non-consensual acts are not covered by Biden's pardon action. Well, duh, that's actual crime. And those convicted under the other articles of the Military Justice Code, which may have been used as a pretext to punish or force out LGBTQ troops, would need to request clemency through the normal Department of Justice pardon process. Biden had previously ordered the Department of Veterans Affairs to move to provide benefits to service members who were other than honorably discharged because of their sexual orientation, gender identity, or HIV status. Biden was at Camp David preparing for a presidential debate with Republican frontrunner Donald Trump set for Thursday. So First Lady Jill Biden addressed a crowd gathered on the south lawn of the White House that was decked out in rainbow for a Pride Month celebration. Um, Nothing against Jill Biden doing this. I mean, it's great that is so prominent as well as the second gentleman, but why not Kamala? She's the vice president after all. Why the first lady? I could understand if this was an education-based announcement because that's Joe Biden's thing. And again, I'm not criticizing that she's active in things, but it seems like she's taking a lot of the stuff that the vice president should be doing. It's like she's become the vice president becoming even less relevant than usual. Just this morning, Joe took another step to right those decades of injustice, pardoning man service members who were court-martialed for simply being themselves. She said to cheers from the crowd. Honoring those heroes, I'm sure there's many of you in the crowd, veterans and their families who have given so much for our country. And that is the end of that article. So, with that, I've covered everything I wanted to in this video. And I will see you guys in the next one.